Hi, this is Joseph Ibarra. Today, I will be talking to you about the JDB versus North Carolina court case, a case related to the constitutional rights of youth individuals. I will elaborate about the background information, case facts, opinions, dissenting opinions, outcomes, and the impact that the case had on special education. I hope you enjoy. Let us begin. Do you remember when you were a child and you got in trouble for doing something? Did you feel like you had a voice in the matter? Did you feel like you had the right to remove yourself from the situation? Or that you had no choice but to respond? This is a feeling all too familiar with children, especially those that are put under stressful situations related to law enforcement. This photo represents how a student might feel when they are brought in for questioning about something they might have done. A picture says 1,000 words. What does this picture tell you? Keep this in mind as we go through the case. Let us begin with background information. A court case held in 1966 called Miranda versus Arizona. Ernesto Miranda was arrested outside of his home after being identified by the complainant. He was taken into custody, and after being interrogated for 2 hours, he confessed to the crimes. His confession was presented in court, where he was then found guilty of kidnapping and rape. He was sentenced to serve 20 to 30 years in prison. Miranda appealed the court's rule, but the Supreme Court of Arizona denied the appeal. Why is this relevant to a case related to special education? Well, he was never read his constitutional rights when he was taken into custody, preventing him from self-incrimination through protection by the Fifth Amendment. Prosecution cannot use statements, exculpatory or inculpatory, unless procedural safeguards were put in place protecting the individual from self-incrimination. The Supreme Court reversed the conviction. However, he was tried a second time with his confession removed from evidence. He was convicted once again and sentenced to 20 to 30 years in prison. This image of lawyer Alvin Moore on the left and Ernesto Miranda on the right, while in court, show how they defend themselves against the ruling. Officers are obligated to read Miranda warnings when a person is taken in custody. The court determines if the arrest is a formal restraint of freedom movement associated with formal arrest after examining interrogation. The Miranda warnings are as such. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to you to represent you before any questioning if you wish. Most importantly, you can decide at any time to exercise these rights and not answer any questions or make any statements. These are the warnings that are supposed to be given to all individuals who are held in custody, including youths. There are 5 non-exclusive factors that determine an individual to be in custody: the language or tone in initial or later questioning, the physical environment, the duration of questioning, the amount of evidence, and the pressure applied, whether being through weapons, physical combat, or psychological, emotional pressures. The case facts are as such. JDB was a 13-year-old 7th grade special education student who attended Smith Middle School in Chapel Hill, North Carolina. JDB was escorted from social studies into a conference room where he met 2 school administrators and 1 additional police investigator, Joseph DeCostanzo. DeCostanzo and administrators began interrogating JDB before reading him his Miranda warnings or contacting his legal guardian. Primarily, JDB denied involvement in the recent neighborhood break-ins and larceny that he was being accused for. However, after pressured by the police and administration, JDB confessed to the crimes. Following his confession, investigator DeCostanzo then informed JDB he could refuse to answer questions and he was free to leave if he wished. JDB continued to talk and was later charged with breaking and entering larceny. He asked if he would get in trouble if he returned the stolen property. DeCostanzo replied with a juvenile detention. During trial, the defender argued to have the confession and evidence removed from trial on the basis of being interrogated in a custodial setting without being read Miranda warnings. The court denied the defender's motion, and JDB was found guilty of breaking and entering and larceny. North Carolina Supreme Court affirmed the court's ruling. However, the Supreme Court of the United States reversed the ruling of the North Carolina Supreme Court, stating due to JDB's age, he was considered to be in custody, and he was not read Miranda warnings, freeing him to leave upon request. The opinions of the Supreme Court holding are as such. Justice Sotomayor presented the opinion, and Justices Kennedy, Ginsburg, Breyer, and Kagan joined. It is beyond dispute that children will often feel bound to submit to police questioning when an adult is in the same circumstances would feel free to leave. Seeing no reason for police officers or courts to blind themselves to that common sense reality, we hold that a child's age properly informs the Miranda custody analysis. The majority opinion voiced that due to the age of JDB and the environment of interrogation, the arrest and ruling violated the constitutional rights of a youth individual in custody who was not read his Miranda warnings. In some circumstances, a child's age would have affected how a reasonable person in the suspect's position would perceive his or her freedom to leave. We have observed that children are more vulnerable or susceptible to outside pressures than adults. The judgment of the North Carolina Supreme Court is reversed, and the case is remanded for proceedings not inconsistent with this opinion. It is so ordered. They voiced that because JDB was only 13 years old, and given the mental status of a child, are much more susceptible to fall into pressures and incriminate themselves when in fact they have the legal and constitutional rights to hold their voice. In counter, the dissenting opinion is as such. Justice Alito presented the dissenting opinion, and Chief Justice Roberts and Justices Scalia and Thomas joined that. The court's decision in this case may seem on first consideration to be modest and sensible, but in truth it is neither. It is fundamentally inconsistent with one of the main justifications for the Miranda rule, the perceived need for a clear rule that can be easily applied in all cases. The dissenting opinion voiced that the age of an individual should not compromise the prophylactic regime of Miranda warnings, meaning regardless of age, Miranda warnings are a one-size-fits-all. Until today, the court's cases applying this test have focused solely on the objective circumstances of the interrogation, not the person's characteristics of the interrogated. Personal characteristics of suspects have consistently been rejected or ignored as irrelevant under a one-size-fits-all reasonable person standard. Then, bit by bit, Miranda will lose the clarity and ease of application that has long been viewed as one of its chief justifications. I respectfully dissent. Because of JDB's age, the dissenting opinion believes that the age and cognitive abilities of an individual should not receive special consideration in regards to Miranda warnings. They believe it should be a one-size-fits-all to clarify the constitutional rights of individuals. The impact that this case made was significant. It displayed precedents for the protection of constitutional rights for students in special education, even for students not in special education. It also made it clear that age and cognitive status of students may influence how they perceive to be in custody and are unable to remove themselves from interrogation. Law enforcement is obligated to present Miranda warnings and should use logical reasoning when interrogating an individual who perceives themselves to be in custody, regardless of the age of an individual. Constitutional rights are warranted to even youths. And it is that common sense reality that children are susceptible to pressures, psychologically and physically, and may feel to be in custody. It is important to educate children about their constitutional rights so that they can protect themselves and become sensible adults. Thank you.